One of the first decisions you're going to make when you're forming a new corporation is what your corporate name is going to be. Business owners consider both business and personal considerations when they're choosing a corporate name. You also want to keep in mind potentially any trademark or logo that you're going to want to have in the future because part or all of your corporate name might be included in that logo. California law does allow broad flexibility in choosing a corporate name. You don't necessarily have to include the words corporation or incorporated unless you're using your own name. So, for example, if I wanted to make Melissa Centeno Corporation, I'd want to have a designation that shows people that it's not just me personally. There are also some restrictions on words you can use. So, for example, words like bank, trust, trustee, you'd have to get approval from the Commissioner of Business Oversight before you can use words like that. Also, words like Olympic or Olympiad are not allowed. And you'll want to stay away from words that imply that you're part of the government, like national, federal, or United States. And if you're starting a professional corporation, like a medical corporation, dental, architectural, engineering, there are more limits on naming that you can find within the Business and Professions Code. Exclusive limits apply as well, and extensive limits to law corporations. So once you've decided what your corporate name is going to be, you may want to consider filing a reservation of that name with the Secretary of State. You can reserve a corporate name for a period of 60 days. Currently, the Secretary of State does not accept email or online requests for name reservations. Unless you're in Sacramento and can drop it off, the easiest way is by mail at the address on the screen. By reserving the corporate name, you essentially make sure that nobody else ends up taking that name before you actually register for your corporation. Note that the Secretary of State is not going to accept your name reservation if it's really similar or the same as a corporate name that already exists. Luckily, the Secretary of State does maintain an easy online search database where you can check if your name's already been used by another company. Once you have picked your corporate name, you're going to move on to filing and preparing the Articles of Incorporation. So, a California business corporation begins its existence when the Secretary of State files the Articles of Incorporation. That's the event that's really necessary to commence corporate existence. So here are the minimum requirements that you'll need as far as information when filling out your Articles of Incorporation. The Articles of Incorporation are filled out online at the Secretary of State's website. We're going to walk through an example of filling out your articles online. You'll want to start with putting in your corporate name. If you've reserved a name, at this point you would have received an email from the Secretary of State with your name reservation number. If that's the case, check the box and put in your number. Otherwise, you can go ahead and click Next. You'll also want to put in your business address. Keep in mind your business address does not have to be the same as your mailing address. You can have a different location where you receive mail as opposed to where you're conducting your business. If you forget some steps, they let you go back to fix it at the end as well. The agent for service of process is the person that receives legal correspondence for your company. It can be yourself. It could be a corporation that's in the business of being a registered agent. It could be your attorney. You need to use a real address and not a P.O. box. The number of shares your corporation is authorized to issue. I would recommend speaking to a CPA and an attorney in order to decide how many shares are appropriate for your company. Finally, review your submission before you sign at the bottom and submit. And if you're going to have multiple classes of stock, you have to list the designation of those classes and the rights and restrictions. So, for example, if you had Class A and Class B stock in your C corporation, one of the restrictions you might have is that Class A only goes to the founders of the corporation and they have voting rights, while Class B goes to passive investors who have no voting rights on the decisions that you're going to make for your company. Finally, you want to make sure to sign the document at the end. Once you've filed your Articles of Incorporation, the next step is to draft your bylaws. Welcome back to another Melly moment. All right, so is it just me or was that extremely complicated?
I get this question a lot. Do I really need a lawyer to help me incorporate my business? Well, if you've been watching so far and taking your notes and paying attention, you can see how there are a lot of different things happening, a lot of moving pieces, and every single thing matters for you to ensure that you're actually protecting yourself against liability by forming the corporation, which is the whole point, right? So, what about LegalZoom and other online do it yourself incorporation processes? Well, while those are legitimate, and if you feel confident with your understanding of not only the formation process, but what you need to do afterwards, what I call the follow up formalities, which you'll hear about right now, then I think it's a great route. But the danger is that oftentimes companies like LegalZoom or other do it yourself incorporation companies, they help to file the articles of incorporation, which you just learned about, possibly do your statement of information, but they're not going to necessarily help you with the follow up formalities, which include ensuring that you've drafted your bylaws specific to your business needs, that you have issued your shares to yourself and to any other partners or fellow shareholders in your business, that you've reported the issuance of those shares to the Department of Business Oversight, that you've gotten the proper licenses for your business, that you've gotten the insurance that you need for your company. So, really, the process of filing the articles and getting a boilerplate bylaws from these do it yourself companies is just the beginning of what it really takes to fulfill the responsibilities of a corporation. Okay, so let me tell you a story about why that matters. So, this was actually kind of recent that I talked to a woman who had formed a nonprofit corporation, which is a type of corporation. So, from the corporate law side, you still have to do all the same things that you would do for any other corporation. The only difference is that nonprofits pay different taxes. That's an IRS thing, and we're not going to get into it. So, she created this corporation. She was all happy about it, but she had done it through a do it yourself website. Well, it turns out that they had not properly informed the Franchise Tax Bureau, which is the agency that does taxes in California, about the formation of the corporation. So she hadn't been paying her FTB taxes. Once the FTB found out that this corporation existed and hadn't been paying the proper taxes, they called up the Secretary of State and were like, hey, cancel this corporation because she's not paying her taxes. Surprise, the agencies talk to each other. So if you're doing something wrong through the Franchise Tax Bureau in the state, they're going to hear about it at the Secretary of State's office. They are friends, they communicate. So what happened? Her corporation was suspended. That means inactive. That means she lost her rights, and anything she did in that suspension period is not covered by the protection of the corporation. So, long story short, not only did it get suspended, but while it was suspended, somebody else jumped online and stole her corporate name and registered their own company under her name. So she lost the name of her company and she lost the brand. And it was all because she didn't understand the follow-up formalities. So make sure you're paying attention to the final half of this module. It matters.
Put simply, the corporate bylaws are the internal documents that are going to give you the rules for your organization. They're going to set forth some of the corporate code requirements, and they're also going to set forth information that your executives, your board of directors, and owners can use in order to understand how to run your corporation. So the two principal functions are one, to provide a useful reference for the owners of the business, even the legal counsel on how to manage your corporation. And two, you can use the bylaws to actually vary some of the rules that are in the corporate code. You can even use the bylaws to create rules that aren't covered in the corporate code. So for example, you might want to have some restrictions on your shares where you decide how owners can sell equity to other people and at what price to ensure that you don't end up in a situation where a fellow owner sells his shares to a third party that you're not comfortable working with. Once you've done your articles of incorporation and drafted your bylaws, you're going to also want to consider the follow-up formalities that come with a corporation. This means obtaining a corporate minute book where you can keep the minutes from your annual meetings and other records. You may want to consider getting a corporate seal, which is essentially a stamp that you'd use on important documents that exist in your corporation. A stock ledger and journal so that you can keep track of who owns shares, when they've been transferred, and at what price you've potentially sold stock in your corporation, as well as the stock certificates that evidence your ownership of the corporation. Preserving the benefits of incorporating require having all these things completed. You need to make sure that every year you're holding your annual meetings. You're keeping minutes of those meetings. Even if you're the sole owner, sole director, and sole executive, you should be sitting by yourself and writing down these minutes for the meetings that you've held. Again, the issue with failing to do this is that a court can pierce the corporate veil and essentially go after your personal assets, which defeats the purpose of having limited liability in your corporation. Also, don't forget, after your corporation has been filed with the Secretary of State, within 90 days, you need to submit something called the Statement of Information.
The Statement of Information is filed online with the Secretary of State's office. In this case, we'll do a limited liability company. If you're filing the Statement of Information, this means you've already created your entity, so search for the applicable name of the entity you want to file for. In this case, we'll do Information Products. As the name implies, the statement is meant to provide further information to the Secretary of State about your entity. You'll be re-entering the address of your business as well as providing information about the management and the chief executive officer.
The Statement of Information is basically a one-page document, sometimes two, that provides additional details to the Secretary of State as far as who your board members are and who your executive team is going to be.